May it please the Court. Your Honor, there are a couple of reasons that I think you should be a little suspect of some of Mr. Merritt's wilder allegations. He has had a habit of standing up and arguing matters that have no factual basis in the record. One of the first ones now was that he spun this web of some sort of conspiracy arising out of Mr. Hertzberg leaving and going overseas. I'd like to bring the Court's attention to the transcript of our motion hearing on January the 12th, when you were trying to set a hearing in the matter and trying to pick a date. On page 71, I state, Mr. Hertzberg has the 15th through the 21st, and you said of February, and I said yes, where he is to be overseas. So that was something that we displayed. Of course, Mr. Merrett hears what he wants to hear and excludes what he wants to exclude. One of the things he apparently didn't hear or doesn't want to hear is that when Mr. Antonio Avila testified, he said in substance regarding that door, I know there was a woman who was trying to get out. He said that. It's in the transcript. And when they came up and put on their testimony, they made a huge point of saying, well, nobody was impeded, there was no interference with anybody, nobody got within 10 feet, etc., etc. Now he has come in here and has essentially accused me and Ms. Coburn of suborning perjury. He's essentially said we got with a trumped-up witness and brought in here some manufactured testimony without any evidence whatsoever. He can chip away and do what he wants to, but that just is a little bit beyond the pale. But let me tell you something, Your Honor. If that was to be manufactured testimony, I did a pretty poor job of it. Because the way you manufacture testimony is you would make it fit that video absolutely to a T. And it wasn't manufactured testimony, it was the testimony of a witness who had a brief encounter and testified to the best of her recollection. And Mr. Merrett made a big point out of the fact that she said he had on a dark outfit. Well, that was what she said the second time the question was asked. The first time she said he had on a hat, which is clear.
I remember that little diatribe there about the hat and nothing else.
So at any rate, this lady was brought in here because Mr. Avila said, I know there was a woman in there trying to get out. We found her, brought her in, had her give the testimony. He's entitled to chop away all day long on her, point out the discrepancies that may exist between what she said and what the video may say and divine some difference there. But accusing lawyers of, in essence, of suborning perjury, I think is a little beyond the pale, but it is in keeping with his general pugnacious ad hominem style of attack counsel, attack the parties that we have seen throughout this proceeding. And it's too bad. It's too bad. There are some unkind things that I could say about his clients, but I've always considered that to be somewhat unprofessional to do that. Now let's talk a little bit about Ms. Bazazian. You know, the videotape shows very clearly she stopped a car in the entranceway. She wasn't supposed to be there. You see these things. You see a little red car have to get around and dodge around the van that is obviously there just off camera. And then as soon as she moves and the car that's in the driveway moves, the van comes in right behind her. So that's a little piece of sophistry that just doesn't seem to me to fall. Now, with respect to Mr. Howie's argument, he suggested that we contrived, I think the language was, we contrived to put Mr. Minton in a bad light. You know, the interesting thing about it is we didn't have to contrive anything with regard to Mr. Minton. He's quite capable of putting himself in a bad light, and he did so. And I will have to tell you that Mr. Howie has done a very nice job, a very smooth job, a very professional job of sugarcoating Mr. Minton's behavior. But that's exactly what it has been. It's been a sugarcoating job. he described Mr. Minton's action as overly cautious. There is a trail of evidence in this case, Your Honor, showing you that Mr. Minton is not overly cautious at all. He's pretty bombastic. He has a short fuse, and from time to time he has a potty mouth. And the final thing is the claim that Mr. Minton has been set up, that service of process was a set-up job. Your Honor, there's no evidence of that whatever. Let's review the facts. On the 20th of December, at a hearing, and I quoted from it, Mr. Merrett, with Mr. Howie's acquiescence, loudly insisted that process had to be served on these people and that serving counsel the amended and supplemental claim didn't work. You gotta serve them. Meanwhile, we got an order to show cause, and the case law says you got to serve him personally. He's out of town a lot of time. He breezes in, pickets, does his thing, and then leaves for parts unknown. So when he comes to town on the 5th, 2 weeks later, and he didn't attend the trial at all. I don't know whether he's got a copy of the injunction at all. He claims he never got a copy of the amendment. So we served him. We served him. There was nothing set up about that. And the picket pole on Watterson Street, he can't claim he wasn't demonstrating. He had the thing in the full upright position. You know what your injunction says? Your injunction says there's certain areas in which you are to do certain things. And it says, only in the orange area do you picket, protest, and or exercise their First Amendment rights. Well, at the very least, dangling this injunction at the tip of a 10-foot pole might be termed exercising your First Amendment rights. Is what he was trying to do, is educate the people on the second floor of the Bank of Clearwater building as to its terms. He was either protesting, picketing, or he was exercising his First Amendment rights in an area that was outside the scope of the injunction. It's interesting how Mr. Merrett characterizes Mr. Avila's testimony about the van stopped in the street. He said it was uncorroborated. Well, I would call it uncontradicted. There was nothing around, no other evidence in there to contradict it, and in fact it was supported by the videotape of the episode. Your Honor, I think we've beat this thing to death over the last few days, and it's with you. Thank you.
Okay, thank you, Mr. Pope.
Your Honor, may I make one statement, not in rebuttal, but to the court and Mr. Pope?
Is it absolutely necessary?
Yes, sir, I believe it is.
Your call.
Your Honor, I apologize to Mr. Pope and to Ms. Coburn if my remarks were taken to impute subordination to them. While I did argue deliberately that the witness was suborned, it was not my intention to impugn either Ms. Coburn or Mr. Pope in that activity.
All right. Tomorrow. 2 o'clock, this courtroom, I'll announce my decisions. Thank you all very much.
All rise. Sir, the court will be adjourned till 2 p.m. tomorrow.